In 1985, the Supreme Court examined an Alabama law authorizing meditation or voluntary prayer in public schools in a case titled Wallace v. Jaffrey. It found the law unconstitutional, stating that it violated the Establishment Clause of the First Amendment. The Establishment Clause states that Congress shall make no law respecting the establishment of a religion. 20 years later, in the case DeWeese v. ACLU of Ohio, the court found a judge guilty of the same thing. Judge DeWeese had displayed a poster of the Ten Commandments in his courtroom. The ACLU of Ohio tried to sue him for it, saying that by having anything to do with one specific religion, he was violating the First Amendment. The Supreme Court ruled in favor of the ACLU. So any reference or remote implication of religion or of being religious is now being frowned upon. People can take you to court and even win simply for mentioning religion. How'd this happen? Isn't the First Amendment also clear concerning our freedom of speech? Many people incorrectly assume freedom of religion means freedom from religion. In other words, you can't bring up religion in front of others, or they might imagine you're trying to force something on them. So they think to enforce freedom of religion, we need to prohibit religion in public. They think that to enforce the First Amendment, they need to violate our freedom of speech. In Wallace v. Jaffrey, the school didn't establish a religion. It wasn't forcing anything on anyone, but giving people who were religious the opportunity to exercise their First Amendment right. In ruling this law unconstitutional, the Supreme Court basically ruled enforcing the First Amendment unconstitutional. In DeWeese v. ACLU of Ohio, the judge was simply exercising his right to free speech, which does actually extend to government buildings. What doesn't extend to government buildings, and what the government can't respect according to the Establishment Clause, is discrimination based on religion. Had Judge DeWeese ruled a case a certain way simply because he disagreed with the religious views of one party, the courts could have punished him. But the Establishment Clause doesn't mean religion can't touch public or work life. It means people can't use it to discriminate. So the real meaning of freedom of religion actually doesn't conflict with the Establishment Clause. That's why they're in the same amendment. These are really just two facets of the same principle. To have freedom of religion, you need to prevent the government from favoring a particular religion. This means that religion doesn't have to be confined to private life, but is allowed in public by the freedom of speech. The U.S. was actually never meant to be a religionless nation. All over Washington, D.C., and in nearly all of our founding documents, even in the underlying principle of our government, as seen in letters on the subject between some of the founders, religion is implied. The Ten Commandments, for example, are above the bench in the Supreme Court. The Declaration of Independence references God. The Constitutional Conventions even began each meeting with prayer. So according to today's society, the Founding Fathers violated the First Amendment. Actually, the Founding Fathers did nothing contradictory to the First Amendment. They didn't establish Christianity as the nation's religion, but exercised their right to worship wherever they wanted. It just so happened that they wanted to do it in a government building while dealing with government matters. They didn't establish a religion when they carved the Ten Commandments into the doors of the Supreme Court, but acknowledged it as the basis of our nation's existence. Acknowledging and practicing a religion aren't the same things as establishing a national religion. So why do people think they are? Despite the seemingly obvious definition of freedom of religion, the right to practice any religion wherever you are, the judicial branch is changing it. As I said earlier, this phrase now means freedom from religion. There's actually a name for this type of behavior: judicial activism. Judicial activists claim that the Constitution is a living document that changes with time and can be interpreted differently in response to the environment. So if people are dying because overpopulation has resulted in malnutrition, I can legally kill however many people I need to solve the problem because the Constitution is a living document. After all, we're all granted the right to life. So when overpopulation is inhibiting our ability to exercise this right, I'm justified in punishing the people who are the cause. There's obviously something wrong with that logic. Judicial activism essentially states that law depends on the judge. They claim that the Constitution is keeping up with the times. But what does that involve? Situational ethics. By allowing the Constitution to change, we're allowing the basis of law, which should be absolute, to vary. While stealing might be illegal today, it might be okay to steal tomorrow, depending on the environment and the judge's values. So judicial activism, the practice of changing definitions to match your values, has affected religious freedom. Rather than meaning the right to practice any religion, society has used judicial activism as the means of changing it to the right to sue anyone who mentions or implies the existence of God. This goes against every principle of the United States. Immigrants come to the U.S. for the freedom it offers. We're known for the rights our citizens have. In fact, we offer more freedom than any other country. But by allowing judicial activism, and more specifically by allowing the definition of freedom of religion to change, we forfeit the rights our nation grants us. We throw away the reality of our reputation. Without the freedoms in the U.S., immigrants have nowhere else to turn. The world loses a unique form of government once we let down our guard and allow definitions to change. Right now we're doing just that. We're letting politicians and society change the definition of freedom of religion. We're letting the judicial branch declare First Amendment rights unconstitutional since they violate our First Amendment rights. People claim they're trying to enforce the laws set forth in the Constitution, but they're actually trying to advance their own agenda, even if they need to do it illegally. Under the name of judicial activism and justice, the foundation of our nation is being destroyed. By manipulating the Constitution, the judicial branch has succeeded in greatly restricting one of the rights granted to American citizens since the formation of our nation. In idly watching as our freedom of religion is manipulated, we're allowing one of the greatest nations on earth to begin its demise.